Okay, we're back on the record in Mateen Cleaves. For the record, I want to say we took a short break to allow the public to come back into the courtroom with all the noise and disruption. Miss Brendel, you are still under oath, ma'am. Are you ready to begin?
Yes, I am.
Okay, Mr. Manning, you may proceed.
Thank you. Ma'am, yesterday you testified and we finished up in the afternoon. Is that correct?
Correct.
Did you go back and talk to anybody, Detective Nerin or anybody, about your testimony?
No.
Who did you talk to about your testimony after you left here yesterday?
My support system, but nobody involved.
Who would be your support when you say your support system? Because you were ordered by the court not to talk to anybody about your testimony. Who would that
Objection,
be?
Your Honor, the court did not order that yesterday.
I don't think I did. I think she's right. I don't think I did. My bad, but I don't think I did.
That's fine. Who's this support system that you're talking about? Are you talking about somebody from the Victims Assistance Program? Anybody like that? Connected to the county?
No. Just
Well, who?
two friends that are here supporting me.
We need the names, Miss Brendel.
Benjamin Dans and William Johnston.
Who?
Benjamin Dans and William Johnston.
Are they somehow connected with this case?
No.
Were they employed at the Whaley Center?
No.
Will you tell me, prior to this incident, your psychiatric history?
Objection, Your Honor. We had to determine the scope, and that was the subject matter of a motion, and I believe if we could approach.
Yes. Yes, of course.
I don't think we're going to show any other videos if that's
Yeah, basically, but it's too heavy for me.
No, Mr. Champagne. 4 of us together.
I just want to make sure the court was able to see.
Okay, we're back on the record. Go ahead.
Thank you. Ma'am, within the previous 30 days of this particular incident, you were involved in psychiatric care, were you not? You were under psychiatric care.
30 days prior to
Yes.
this incident? No, I was not.
In fact, you take medication, do you not?
No, I do not.
You don't take any medication.
You know, I'm going to say, as it relates, he has to do it to a scope, because we talked about a scope, and that question was so vague and not tailored to the scope. Could we have the scopes the court talked about?
Judge, could we follow the rule that the court laid down?
Yes, because
Or else we're gonna get into that same thing.
We did discuss a certain two things. You may proceed. Mr.
Thank you.
Manley.
So you're not taking any psychotropic medicine?
No, I'm not.
Okay, do you know what psychotropic medicine is?
Yes, I do.
Okay. What is it?
Your Honor, I'm going to object.
Did we have a ruling earlier today?
We did, however, you're just a little bit outside what I said. Now let me consider your question.
Okay.
I think based on her experience as a social worker, her degree at CMU, and her work experience, she would be, if she says yes, she knows what it is, then she would be able to define it. And I don't think asking her to define it is without the scope, is outside the scope of how I limited this.
Thank you, Judge.
Is that so I can ask her?
Yes.
Yeah. So what is the psychotropic medication?
It's medication used to help with mental health diagnoses.
Can you give me an example?
I'm sorry, I didn't hear the question.
Can you give me an example?
Your Honor, now at this juncture, we're going far afield, because the answer, the question was tailored. Were you taking it within 30 days? She said no. You asked what it was. You allowed that. Can you give me an example? Now this is just not relevant.
Mr. Manley, what's the relevance?
Well, if someone says they know a general idea, I know baseball, and someone says, okay, tell me about baseball. And they say, well, I know that there used to be a Tiger Stadium. Well, that really doesn't tell you what you know. I want to know what, that's a generality. I want to know if she actually knows what a psychotropic medication is.
Well, she already defined it. Asking her to give...
I can move on, Judge.
Thank you.
That's an easy one. Not a problem. Ma'am, you were taking medications at the time of this incident, is that correct?
No, I was not.
You were not. So, you remember talking to Nurse Most at Genesis Hospital, do you not?
Yes.
And you remember telling Nurse Most, in answer to the question on the questionnaire, that you in fact were taking an opiate. Is that correct?
I was not taking it.
So you were not taking Vicodins?
No, I was not.
So when you put that on the sheet, that would be incorrect.
I may have been prescribed it, but I was not taking it the night of the incident. No.
When was the last time you had taken it?
Objection, Your Honor, as the scope,
It goes to the scope. I'm going to allow it.
No, but the last time, if it's outside the scope, he has to, I'm sorry, Judge, if you could ask whether it was in the last 30 days, because the last time...
Okay, yeah, the last 30 days.
Thank you.
On the opiates as well
On the opiates,
as the psychotropic?
No, on the opiates.
We'll back it up. You said you may have been prescribed it. Were you prescribed it or not?
If I put it down on the questionnaire, then I would have been, that would have been the truth.
Can you speak up, Ms. Brenda, please?
Well, wait a minute. You said you may have been prescribed it. Either you were prescribed it or you weren't prescribed it.
If that's what's on the questionnaire, then I would have been prescribed it. But I cannot tell you at this time, over a year later, that I was prescribed it, no.
Well, who's your doctor?
Objection, Your Honor. This probable cause hearing, that is a typical discovery issue. You cannot do that. She has rights to privacy under the Michigan Constitution Victims' Rights Act. A witness has rights to privacy. That violates HIPAA. She does not have to indicate who her doctors are. Absolutely, positively not, Judge. That's a discovery issue. It has nothing to do with probable cause.
Can I respond? Or
Yes.
Samuel
Yes.
Jackson used to say, may I report? The fact of the matter is, I don't know if she bought it on the street. I don't know if she, in the 30 days the court ruled was for psychotropic medications, not for the opiates. So now we're mixing apples and oranges again, and we're getting the choppy same thing again, that the court ruled earlier, and I should be allowed to ask. She said, told the nurse that she took Vicodins, which are opiates. She's admitted today that if she said that, it would be true. So I don't know when she took it. She says, if I said it, it's true. I should be able to ask that. If in fact there's somebody out there and she wants to somehow, it violates the privacy, in terms of a doctor, just have her tell me that a doctor prescribed it.
And then ask that. And I'll allow him to ask that. I don't want the specific name of the doctor.
No, I don't need that, but I need
might violate HIPAA.
I need to find out if it was bought on the street.
Objection. And the reason why, Judge, is because even if it was bought on the street, and that's improper character evidence, that would implicate other bad acts, which would be that you cannot do under the rules of evidence. And that's why I understand the court's ruling, but allowing that kind of question to be asked, that violates the 404B, other bad acts.
Unless it goes to a pattern, motive, scheme, or design. You may proceed, Mr.
Thank
Manley.
you. Did a doctor indeed prescribe the opiates to you?
Yes, the doctor would have prescribed it.
Why did the doctor prescribe that?
Objection, Your Honor, relevant. I'm sorry. Why a doctor prescribed it it goes into the privacy of her health. She doesn't have to answer that question at the probable cause hearing, Your Honor. It's not relevant.
Mr. Manley?
Again, may I retort?
Yes.
If in fact,
Mr.
if in fact she's taking them and they're prescribed, my next question is going to be right on the bottle. It's going to say not to drink with alcohol, and it's going to have a time frame,
Well, you can ask
and
that
so
question.
forth.
Just
I can't
ask
ask any questions.
I'm catching that. Ask her that question.
Ma'am, were you indeed prescribed the medication?
Yes, I was prescribed the medication.
Did the medication come in a bottle?
I don't believe I even filled the prescription.
So you told the lady that you take this medication, which is what is on the form. Where's the form?
Your Honor, I'm going to object. She didn't say she said it was prescribed her. That was the witness.
No, I'm sorry. On the exhibit, she says she was taking it, and I'm going to allow the question. You put the exhibit into evidence.
Tell me this. I'm referring to right on front page of B of the Nurse Mo's medical history. Can you see that?
Yes, I can.
Can you read that out loud?
Hydrocodone.
No, where it says current medications.
Current medication.
Okay, so hydrocodone, okay? So that says current medications, correct?
Correct.
So if you have a current medication, that doesn't mean I didn't even fill it, because if you didn't fill it, you don't have a current medication, do you?
But it also does not ask, am I taking it? Or did I take it that day?
It says current, does it not?
But it does not say, was I taking it?
Listen to my question. It says current. You can look over there, but you need to answer my question. It says current.
I am answering your question.
And current means, under this particular time, look right at me. Current means that, is something funny?
No.
Current means, and the reason they're asking in this context, are you taking a medication currently, does it not?
It does not say, are you taking it currently? It says current medications. It could mean current medications I'm prescribed, current medications I'm taking that day, but it does not say current medications that I took or that I am taking.
Well, using that particular line of argument, then why doesn't it say past medication? Why doesn't it say medications you're not taking?
Objection. Those questions are argumentative, Judge.
Yes, and I allow the continuing, make a note.
The fact of the matter is they're asked right there so that they can do a proper medical treatment. You're a college graduate. You wouldn't put down current medication if it's something that you weren't taking, would you?
I would put down medications that I'm prescribed.
Because if it's prescribed, they need to know if you're taking it because it might have a drug interaction.
Objection. That's speculation on her part about why they would need to know it.
I don't believe that's true, Miss Lindsay. This court has been in several doctors. That's been explained to me. I'm going to speculate that she's been told that too. So the court is speculating. I want to hear the answer.
So the fact of the matter is, ma'am, you know when you're taking opiates that you're not supposed to drink. Isn't that true?
I did not take it that night.
You don't even know if you filled it, so how do you know if you even took it that night?
Because I know I didn't take it.
Well, explain to me, because I don't know. If you don't know that you didn't even fill it, how would you possibly know that you didn't take it?
Because I know that I did not take it. If I don't know if I filled it, I don't even think I filled it. So I know I wouldn't have taken a medication that I don't think I filled.
Then why would you even tell the doc, why would you tell the expert nurse that you were taking current medications? Stop here. Why would you tell her if you were taking, because the question's clear, current medications.
Your Honor, this has been asked and answered. Why she told her, this has been asked and answered.
You want to respond?
It hasn't been explained, because she just said...
I believe that the answers have been unresponsive, and I'm going to allow him to ask the question, and I'm going to instruct the witness. She's doing two things, I noticed. She looks to your side for the answer. I want that stopped. And I'm going to instruct her to ask the question.
And just for the record, I
answer
did not notice that.
Okay, the court knows.
Right.
Go ahead, whatever you want to say.
Is the court observing us giving her any answers?
No, I don't.
Thank you.
And she may just be looking over there to keep her eye on the victim advocate to be comfortable. I don't know why. I'm just cautioning the witness. Please don't do that, and I am cautioning her to answer the question that she's asked.
Thank you, Judge.
Ma'am, you're a college graduate, correct?
Correct?
You've indicated that you have some knowledge of psychotropic medications. You gave a definition, correct?
Correct.
And there's a question here when you went on a medical examination that says current medications, correct? I showed that to you.
Yes, you did.
And in your education, current means now, correct?
Correct.
But yet, and you wrote hydrocodone, which is an opiate. You wrote it down. Now today...
Objection, Your Honor, she didn't write it down. I mean, can the record be clear? At least the record should be clear. She didn't write it down, the nurse wrote it down.
I think the record should be clear that she gave the answer and the nurse wrote it down.
You gave the answer. Do you have any quarrel with the hydrocodone?
No.
Would you look over here? Who, by the way, who are you looking at over
She
there?
might be looking at the victim advocate, Mr. Manley, or maybe just looking at you makes her nervous. As long as she's not looking to the prosecution level for answers, I'm happy.
That's fine. Were you instructed? Because you said you never even got the bottle?
I don't remember even filling that prescription.
So how, if you didn't remember ever filling it, why in the world would you say you were currently on it?
I told her the medications that I was prescribed.
It doesn't say prescribed.
Now we're being
That was
asked
my-
and answered.
Now we're being asked and answered and argumentative.
All right,
Move
well,
on, Mr.
Not a problem. Tell me about hydrocodone, the opiate.
What about it?
Where somebody had it, you said you didn't fill a prescription, which means that you got a prescription.
Yes.
Well, if you get a prescription, either the doctor or the pharmacist gives you a sheet and tells you about drug interactions, tells you about whether you can drink alcohol on those things and so forth. Is that correct?
Correct.
And it talks about types of things that can happen if you mix medications and or alcohol, does it not?
Correct.
Okay. Now, we've heard a lot of talk here today and yesterday about you running out of a room, is that right?
Yes.
Okay. And you were very descriptive in your term run, right?
Yes.
I mean, run. I mean, run means to move at a pace faster than walk, right?
Yes.
Okay. Now, if the video indicates that you're walking, I mean, just walking in a normal kind of a walk, would that be because the video is wrong, your memory is wrong, or like I suggested yesterday, you don't remember any of this?
What's the question?
The question is, when you say run, is that because somebody told you that you ran, or because you don't remember? Or are you lying?
I said run because that's my memory of what happened.
So you say ran. So if the video shows that you're walking, you could very well be mistaken. Is that correct?
My memory is that I ran from the room.
Okay. You also said that your clothes were all the way off. Is that right?
No, I did not say that.
All right. Were they partially off?
They were partially off.
What was off the first time you came out?
I believe everything except my bra.
Your bra. Okay. Now your bra, you suggested that you've been sexually assaulted. Is that right?
Yes.
Then you were sexually assaulted on that day, right?
Yes.
And you would suggest to this court that that was a very traumatic experience, correct?
Correct.
Certainly it's had a devastating effect on you, correct?
Correct.
And you said that at least at one point in time you had that bra on. Is that right?
Yes.
And that was during part of the time that you were sexually assaulted, correct?
Correct.
And why in the world would you ask Detective Nearing if you could have that bra back? Is that a memory, like a trophy?
No. And it might seem stupid now, but it's an expensive bra. It's one that I liked, and it's one that I wanted back.
So you wanted the bra back that you supposedly were sexually assaulted in.
Objection, Your Honor, it's irrelevant.
Goes to credibility.
No, it doesn't.
Mr. Manley, I'm going to go against you on this one. She
That's fine.
said why she wanted it back.
I can move on. How many people were in that room again?
Objection, Your Honor, that was asked and answered several times yesterday.
Can I set,
You may respond.
I'm just bringing the witness back. It's hard to go back because counsel has not followed the court's ruling in terms of objections. It's hard to go back and set a scene.
I understand. You may refresh where you want to go to.
Thank you, Judge. Ma'am, you said that yesterday there were just 2 people in that room. Is that correct?
Which room?
Well, you tell me what room it was.
I'm asking what room you're referring to.
At the hotel. What room was it?
I don't know what room it was.
Is that why you asked Mr. Cleaves as you were walking in, which room are we going into?
I don't remember.
Objection assumes facts not in evidence.
It's a question. That's an absurd objection. Either she can say she said, I'm...
She can either deny it was said, say she doesn't remember, ask the question.
Yes. And the counsel only raised that objection because she knows there's a witness that said she did. So, I mean, if you're going to object to those kinds of questions, I'm going to tell why.
Mr. Manley, talk to the court.
Thank you, Judge. So, you don't remember which room it was?
Correct, I don't remember which room it was.
Okay. And again, that is the reason you asked Mr. Cleaves as you pulled up which room to go into. Isn't
I
that
don't
right?
remember asking, and I've never said that I asked what room it was.
Okay. But you don't remember a lot of things from that night, is that correct?
Correct.
Now, we showed you a video, is that right?
Yes.
Did you see yourself in the car?
No, I saw someone in the car.
You don't know if that was you?
You couldn't see my face.
You don't know if that was you?
I'm saying that you cannot see from that video that that is me in that car.
My question is, do you know if that's you?
It could be assumed that it's me in the car.
Well, I don't want to assume anything. Did you recognize Mr. Cleaves?
Yes.
Did you recognize your purse?
I recognize a purse.
Did you recognize a female in there fixing her hair? Did you see a female?
No, you see an arm move. You don't see hair fixing.
Do you see, like, it appears to be a compact and somebody doing it with some lipstick?
You do not see a compact. You see an arm move.
So, well, whose arm was that?
Like I said, it could be assumed that it's mine, but you can't see my face.
When you say it could be assumed that it's yours, you're almost very defensive. I mean, you're not saying that at that particular time, date and time, that you weren't there, are you?
No, I'm not saying that.
So that's you. True.
I'm saying that you can't see my face. It can be assumed that it's me, but no, I could not say that it's 100% me in that car because you cannot see my face.
So it may very well not be you at that time?
I didn't say that it wasn't me. I didn't say that it was. I said it can be assumed based on the time frame. It could be assumed that it's me, but you cannot say it. You cannot see my face and say 100% that that is me in the car.
So you may very well, based on your memory and looking at that picture, you may very well be somewhere else at that time, based on what you've just said.
I'm just saying that you cannot say that it's me in the car. I'm not saying that it's not me in the car. I'm just saying that you see a person in the car. You cannot say that it's me. You cannot say that it's not me. I can assume that it's me in the car based on the time frame and what I remember from the events of that night.
But based on the converse of that assumption, it could be somebody else.
Objection, Your Honor. Question argumentative.
I'll move
She's
on.
answered the question.
You don't recognize your purse?
I recognize that there's a purse in the car.
Did you have a purse that night?
Yes.
Did the purse look like the one that's in the car?
It wasn't clear. As you can see, a purse. There's no distinguishing factor that it's my purse.
Could you see the color of the purse?
No.
Was it light colored? Was it dark colored?
Objection, Your Honor. This is relevant. She's answered the question as it relates to this.
What's your response?
I'm establishing that she's not admitting that it's her, and I'm going through
And you
other...
think the court hasn't recognized that fact?
I'll move on.
Thank you.
The vehicle that you viewed in that particular video was a black vehicle, was it not?
Correct.
Did you recognize it?
Yes.
Did you recognize it as Mr. Cleaves's?
Yes.
Did you recognize Mr. Cleaves?
Yes.
This person that was in the vehicle, did you recognize that and someone getting out of the vehicle?
As far as him getting out of the vehicle or the passenger getting out of the vehicle?
When you say him, who got out of the vehicle?
Mr. Cleaves.
Okay. That's this gentleman over here.
Yes.
Okay. And someone, assuming it was you, was left in the vehicle, correct?
Correct.
And the vehicle was on, correct?
Correct.
The keys were in the car, right?
Correct.
Mr. Cleaves exited the vehicle, correct?
Correct.
So assuming it was you were, and you felt you were in danger, you certainly could have locked the door, right?
Correct.
Driven away, right?
That would be drastic, but correct.
Honked the horn.
Correct.
When you say drastic, you said that you were in fear that nobody knew where you were, right?
I was concerned that nobody knew where I was.
So when you say concerned, that's less than fear, right?
Correct.
So if someone was to say that, try to characterize your state of mind is that you were fearful at the hotel, that would be overstating the case. Isn't that true?
No.
So you were fearful?
In the room? Yes.
No, I'm talking about at the car.
At that time? No, I was concerned.
So you were concerned, but not concerned enough to shut and lock the door.
Correct.
Not concerned enough to drive away.
Correct.
Not concerned enough to honk the horn.
Correct.
And not concerned enough to, at that point in time, notice that you were at the Nights Inn Motel without your boyfriend?
I have no memory of that video, so I've said that I was concerned. I was concerned. Nobody
Your
knew where I
video
was.
tends to come and go, or your memory tends to come and go.
Yes.
You didn't remember anything about the drive from Sweetwater to the gas station, right?
Correct.
And then you said you were having fun with the moonroof, and you said you remembered that.
Yes.
You said you didn't remember that the gas station was well lit, right?
Correct.
Objection, we're going over, objection. We're going over ground that's been gone over before. She said that yesterday. These are asked and
Just a
answered.
minute. Mr. Manley, your response?
I'm going back to, because I'm going to get her memory, I'm bringing back to the series of things, because credibility in this case is important, and the fact of the matter is she has selective memory.
I'm not going to call it selective memory, but I am going to say that it appears there are times she is lucid and remembers, and times that she does not.
If the court I don't need to, if the court understands that, I can move on to
I
another
understand
subject.
that 2 hours ago,
Good enough.
yesterday.
All right. When you said yesterday that you went in and you had a casual drink inside the hotel room.
I'm sorry. She never said that. He
Yes, she
misquoted.
did.
No, he misquoted from the transcript yesterday, and I corrected. She never said casual. She said she had a drink. He inserted the word casual, which is the reason why I was objecting yesterday that he wasn't using what was written verbatim. That was the objection, that he injects words which were not what she said.
She said she had 2 sips out of a drink fixed by Mr. Cleaves.
Yes, she did say that, but he said casual.
She did.
I'm
say-
not going to quibble about one word.
Well-
Casual as opposed to forced down her throat.
But
So you're now in the room and you're having a drink, right?
A drink was made for me, yes.
Yeah. And then you know, the thing with it is, you had drinks at the golf course, right?
Correct.
You had drinks at Sweetwater.
Correct.
You had shots at Sweetwater
Correct.
of high volume alcohol.
objection asked and answered, Judge.
Can
Those questions.
I make a point here, Judge? Sometimes you have to lay it. If you don't lay it, then we've got this going on in terms of lack of foundation.
I know it.
I mean,
These questions were asked and answered yesterday, Judge. The foundation, whatever foundation he claims he's going to lay, is on the record from the questions that were asked yesterday, asked and answered.
You may proceed, Mr. Manley.
thank you, Judge. Ma'am, you had high proof shots, right?
Correct.
And I'm assuming that you're not an alcoholic.
Correct.
Okay. So you drank those shots in a fairly short time frame, correct?
Correct.
Okay. Then you go to the hotel, right? Or motel.
Correct.
Okay. You go into the room, right?
Yes.
You have at least a sip of another drink, right?
Yes.
And the fact of the matter is, ma'am, you kissed Mr. Cleaves, right?
Correct.
You never told him no, right?
I said I wanted to go home.
One time.
Your Honor, these questions have been
Can I-
asked.
can I
I'm
get-
sorry, Judge, I'm sorry, this is cumulative. The questions were asked and answered yesterday. All of these same questions were asked and answered yesterday.
I will consider your objection continuing.
Thank you. And ma'am, after you kissed him after you told him you wanted to go home. You testified to that yesterday, correct?
Yes.
All right. And then you had consensual sex with Mr. Cleaves. Isn't that true?
No.
And isn't it also true, ma'am, that the alcohol hit you at that point during the consensual sex, the activity, and you vomited in the bathroom?
I do not remember vomiting in the bathroom.
You don't remember, or you didn't do it?
I don't remember if I did.
Well, if there was vomit in that room before you and Mr. Cleaves left, and you had just had these shots, wouldn't it presume that it was you?
Objection, assuming facts not in evidence.
What's the fact not in evidence?
That she vomited in that room. As a matter of fact, I have a statement from,
If this is going to be she vomited twice, we've got a witness.
no, I have a statement
Is
that
this
was
an
sent to me
objection?
by, I have a
She
statement.
claims it's an objection. I haven't heard.
Assuming facts not in evidence. My objection is assuming facts not in evidence. I
Well,
have,
you know, I've heard this before. It might have come from Miss Dowdell, or it might have come from the nurse, But I heard about this before.
Ms. Dowdell said she vomited while she was in Ms. Dowdell's room.
All
Nothing
right.
about vomiting in Mr. Cleaves' room is what she's asking, which is assuming facts, not evidence.
See, this is the problem that we have, and this is why I made the objection. When the people of the state of Michigan, as represented by Ms. Lindsay, stand up, and they know they have Johnny Mayfield's statement, the cleanup guy from the Knights Inn, who indicated that he in fact cleaned up vomit from that room before it had been. So she knows.
No, we have a statement that was sent to me by Mr. Fishman, who was working as co-counsel from, for Mr.
Could we
for-
approach?
No, you
You will approach.
You put everything,
You will approach.
Excuse me, Judge, they're talking at the same time, and I cannot get a record when they will not stop talking at the same time.
That's why I brought him up.
Now, what's your, okay.
If it's something that Mr. Fishman has said, then that's not appropriate. It's an attorney-client privilege, how she can do that.
Well, let me establish this. Let me establish this.
And something from Mr. Fishman and an attorney-client privilege as part of a plea negotiation, you want to read that into?
No, it's not, it's not attorney-client privilege because it is shared with.
From Mr.
because
You're talking against one another
there was
again.
something that was shared to me by,
If we're not on the record, do you want to wait?
yes.
I'd ask that an offer of proof be made at the bench if it's something from...
And we're on the record. Now, Miss Lindsay,
Yes.
who in fact prepared this statement?
This statement came from a David O. Norris, who is a private investigator employed by Mr. Manley. It was sent to me by Mr. Fishman, who was co-counsel on the case during the investigative phase.
And why is this not work product of the agent of the attorneys?
Because they sent it to me, which means when you disclose something to a third party, it is no longer privileged and or work product. It was shared with me.
I'll buy that.
Okay, and they were outlining investigations that they had done and a witness statement of Pam, who worked at the Knights Inn.
Okay, I have a subpoena for her, so we
Pam.
can just wait.
Judge, but no, he talked about what Johnny Mayfield said, who we don't have a subpoena for, who's not going to testify. Pam has been subpoenaed by defense counsel, and according to the statement taken by the private investigator, Pam said she went into the room 121 room that night, and there was no evidence of any vomit in the room that night. So despite what Mr. Manley just said on the record, his own investigator talked to somebody who said there was no vomit in the room 121 that night, and that's why I said objection, assuming facts, not evidence. That's what my objection was. Until she comes in or somebody comes in.
All right, I got it.
Thank you.
I've never seen anything like it.
I never have either.
Pam also said that she's a liar and she was never raped. Did you want to read that in?
And Pam also told other stories too.
I mean...
Okay, look, we're not going into this. This lady is an anticipated witness. I'll deal with that when I get to the anticipated witness.
Thank you,
The
Judge.
only reason I say she's anticipated is because you filed with the court a copy of her subpoena.
I understand, Judge.
Please, can we move on?
I have tried. So, ma'am, you say you run out with your bra, is that right?
Correct.
And then you go back into the room, is that right?
I was brought back into the room.
Okay, you go back into the room, is that right?
Yes.
And then you come out again, is that correct?
I ran out again, yes.
Yes. And you say I didn't understand that, because the prosecutor asked you yesterday about the size differential between you and Mr. Cleaves. You forcefully pushed Mr. Cleaves off you?
I remember moving him and running out of the room. I did not.
Okay, wait a minute. Are we talking about the first time or the second?
Well, we'll start first. Did you push Mr. Cleaves off the first time you were in the room?
First time she ran out.
First time you ran out, did you push Mr. Cleaves off?
I believe so.
Okay. So you pushed Mr. Cleaves off, and the second time, again, you pushed Mr. Cleaves off. Is that what you're stating?
Yes.
Okay. And you're stating this because you remember this yourself, not because what other people have told you?
Yes.
Okay. And you stated that you had your bra on the first time, right?
Yes.
And you said Mr. Cleaves assaulted you between the first run out and the second run out, correct?
Yes.
And you said that he moved your panties to the side, and actually in some detail you described the sexual assault, right?
Yes.
So in order for that to be true, Mr. Cleaves or yourself would have had to put your panties back on from the first run out to when you were assaulted. So Mr. Cleaves, before assaulting you, would have to help you, or you put your panties back on before you were assaulted. Is that right?
I don't remember doing that, so I can't tell you that that's right.
Well, you don't remember doing that. You, in great detail, you described your panties being moved to the side.
Yes.
And your panties were not on when you ran out the first time or walked out the first time. Right?
Correct.
So, the first time you got the bra, the second time you got the bra and panties, right?
Yes.
And Mr. Cleaves brings you back in that time, correct?
Correct.
And then the third time you come out of that room, you're almost fully clothed, right?
Yes.
So each time you go into the room with Mr. Cleaves, you come out with more clothes. Isn't that true, ma'am?
Yes.
When did you give Mr. Cleave Michael Bryant's number?
I don't remember giving him Michael Bryant's number.
Did you see Michael Bryant get that number at Sweetwater?
No, I did not.
Was there anybody in the room, to your knowledge, and I've asked this, but I'm going to ask it again, besides you and Mr. Cleave, that you were aware of?
No.
So, you texted Mr. Cleaves earlier in the evening, did you not?
Yes.
And you had Mr. Cleaves' phone number saved into your phone, did you not?
Yes.
Do you have your phone with you?
It's in another room, but it's here.
Would you recognize if I showed you, do you remember Mr. Cleaves' number?
No.
If I showed you a number, would that help, maybe help refresh your memory?
No, I don't remember his number.
But it was in your phone, so it's available to you, available to me, so you could go look it back up?
I have a new phone and deleted the number from my old phone.
Okay. But you indeed had it that particular evening?
Yes.
Okay. In fact, you had text back and forth that we talked about.
Yes.
Okay.
Excuse me, Mr. Bailey, may I ask a question?
Yes.
Clarification for the court. Ms. Brendel, you said you have a new phone and you deleted, and I missed what you said. You deleted all the numbers you had, or you deleted all the text messages? What did you delete, ma'am?
It was on my old phone, and I believe I deleted the number after.
Just this one number, or all of them?
Just the one number.
Go ahead, ma'am.
You've given a couple different stories on taking your clothes off, so I'm safe to assume you don't know how your clothes got off?
I've said that I don't remember how my clothes got off.
Okay. And you said you don't remember talking to a police officer at the scene?
Correct.
But you do remember talking to a Colleen Dowdell?
Correct.
Okay. and Colleen Dowdell and the police officer were there at the same time.
Correct.
In fact, the police officer, Sergeant Johnson, removed Colleen Dowdell from the room so he could talk to you privately, did he not?
I don't remember.
But you remember talking to the lady that you said you mouthed the words help to. You remember that, right?
Yes.
But you don't remember talking to Sergeant Johnson, who you said nobody ever assaulted you. Is that correct?
I don't remember talking to him, no.
Thank you very much.
Is that
That's.
the end?
I'll keep her on. I'd like to preserve her as a possible for recall, but yes, at this point.
Miss Lindsay, I'm going to ask you, do you want a break before you do your redirect?
I just need just 2 seconds, real quick, and then I can let the court know whether I'm going to do redirect. So.
I didn't know this was going to be a full-blown conference.
You're off the record.
I know, but I still didn't think it was going to be a full-blown conference.
Your Honor, I have no redirect.
You have no redirect?
That's correct.
Just a moment, Judge,
Let me get back on the record,
Okay, sorry.
Okay, I'm ready, Judge.
Okay, we're back on the record, and Mateen Cleaves and Miss Lindsay, would you please repeat what you just said?
The people have no redirect, Your Honor.
Thank you. Ms. Brendel, you're excused from the courtroom. You're not to talk to anyone about your testimony, not even your support people. And I would like you to go with the victim advocate. You are to stay in the building until this case has ended. In other words, I'm hoping by 4:30. But if not, I may have to bring you back. Do you understand?
Yes, I do.
Thank you.
Your Honor, according to the Victims' Rights Act, she can speak with the prosecution. The Constitution
I'm
says-
asking her specifically not to speak to any other witnesses
Okay.
or her private support staff.
Okay.
Right.
Well,
About her testimony.
actually, the Constitution, if the people
I
are not...
just said I didn't want her to talk, Miss Lindsay. Please don't argue with me.
I'm not trying to argue, Judge, but I'm just trying to point out the Michigan Constitution as it relates to victims' rights specifically say, as it relates to support people, she has a right to speak with them. If they are not, and they are not witnesses, her support staff is not witnesses. The Constitution says she has a right.
These are merely friends. They are not professional support staff. I don't know who might be called if this goes to trial. I am asking her, until this preliminary examination, I'm not asking, I'm ordering, until this preliminary examination is completed, one way or another, I do not want her talking to anyone that is not victim advocacy, you guys. I don't want it because I don't know what might be said to somebody else who would then become a witness. So I'm ordering that.
Okay, until the exam is over, okay?
Right.
Okay, fine. I still believe the Constitution doesn't... but
I've already ruled.
I understand, Judge, but it's one of my positions on the record.
Do you have another, she walked out. Do you have another witness, Miss Lindsay?
No, Your Honor.
Are you resting at this time?
Yes, I am.
We have to clarify the exhibits, Judge. I've been trying to keep track, and since we're at the end of our presentation of proofs, it's my understanding that there are 139 marked exhibits on the exhibit list that we provided to you, and that all of them, and then of course Defense Exhibit A, which we stipulated to. It's my belief that all of the exhibits have been admitted,
That's not
with the
correct.
exception of Exhibit 94.
That's not correct. I have not to the best of my knowledge, and I'm
Right.
going off the list you've given me, I have not admitted 1, 2, 3, 4, although I think I saw them.
We showed them, Judge,
Yeah,
so they
but
had to have been admitted.
I don't believe I
May I
admitted them
formally move to
formally.
admit all of the exhibits with the
No, I'm
exception
not
of-
going to allow you to admit all. When we take a break for lunch, tell me which specifically I have admitted. Bring me in a list of what I have admitted. And, because I don't believe I've admitted all 130-some exhibits.
I think that counsel
Let me ask.
Your Honor, I do have Exhibit 1 admitted. I do not have Exhibit 2, 3, and 4 ever moved for admission. I show Exhibit 12 was never moved for admission. Exhibits 39 or 40 or 41 never moved. I also show Exhibits number 79 through 92 were never moved for admission, and I show Exhibit 94 was not moved for admission.
Okay, wait a minute. All right, Mr. Muscat, would you please?
But in interest of fairness to the court and counsel, Ms. Lindsay is whispering in my ear that they have a transcript showing them admitted.
We
And
have.
they may have, that's
Could
why
we take
I
a
asked.
break and go over it together and then report back to Your Honor
Yes,
in
because
fairness?
they were admitted out of order, and I may not have marked them on my list as admitted. I want to be fair to the prosecution. If it was admitted, I want to mark it as admitted. So, Ms. Lindsay, I'm going to give you this list.
And Your Honor, I also recall that they gave us a second list. So I had two different lists because our first list didn't have good description.
This
and
one-
then you gave us a more descriptive list, so I may have
This
missed
list is
something.
what I would consider more descriptive.
Okay.
Ms. Lindsay, I'm giving you this list in a red pen. Between the two attorneys, would you decide what I have admitted, what I have not? Those that I have admitted, please mark with a red pen.
Okay.
All right?
That would be, thank you, Your Honor, for that
If
opportunity.
5 after 11, I want to, can you get it done by 11:15?
Oh, I'm sure.
Yeah.
And we're just looking at a transcript.
I would like to reconvene at 11:15, all right?
Thank you, Your Honor.
Oh, no. Good enough.
Lisa just walked out. You don't want to be on camera.
I don't care who it is. Is it Lisa or is it
Could you see?
Well, yeah. No, but I want to finish. I want to finish. So Ryan's called now. Ryan's called now. Big man.